All right, welcome back to the Sandler Law Podcast. My name is Theodore, or Tuvia Sandler. I'm the managing partner of Sandler Law, a commercial litigation firm in Miami. If you like this episode, to support the channel, please like and subscribe. Today, I'm joined by a very interesting guest, Aaron Lukken. He specializes in international service of process. Welcome, Aaron.
Thank you. Thanks for having me. It's good to be here.
All right, so just tell us a little bit about your firm and your background, how you got into all this.
Well, how I got into it is the easy answer. I got into it the same way Forrest Gump got into the White House. I got lucky and woke up one day and thought, it worked. We are a fully remote law firm handling service of process abroad. I have a staff of 5. 2 of us are lawyers. 3 of us are about to be lawyers. So by the time the summer bar results come out, we're going to have 5 lawyers and my wife, who is my office manager.
Right.
So
Okay, cool. And
that's
I forgot to mention the name of your firm. It's Viking Process Servers, right? Or
Viking Advocates.
Viking Advocates. Sorry about
Yeah,
that.
and we very much have to differentiate from process servers because so much of what we do involves government officials, local council in other countries, and that kind of thing. Process servers can't go to the extent that we can go to.
Yeah. So I had a guest on previously. It was kind of a I'll call it vanilla flavored process server. Although there's no such real thing as a vanilla flavor. They just do process service in the U.S. in the state of Florida. Obviously, this is a different ball game, and just to kind of explain to people in the audience, why it's so different when you get into international. If you could kind of give us some background and the Hague Convention and just kind of the basic layout of how process works.
Sure. In most of the world, the Hague Service Convention is going to apply. And that's not me saying it, it's Sandra Day O'Connor saying it. And it means different things in different places. But the bottom line is, no matter what venue the case is being heard of here in the US, the rules from that venue are not going to govern how things are done in China, Germany, Ireland, what have you. Not only do we have the treaty to be concerned about, but we have the laws and the rules and the common practices in that foreign country or that foreign jurisdiction. The Hague Service Convention sets out essentially 3 ways to serve a defendant. The
And
first,
sorry to interrupt. Just so people understand, the Hague Convention is an international treaty
yes,
that. So it sounds like the majority of countries in the world are signatories to.
I can't say a majority of the countries, but a majority of the vast majority of the world's population is covered by the convention.
Okay.
So it's very rare that we're working outside of the convention. But it's kind of a quirky thing because every country in it sets up what's called a central authority, which is either a court or some government agency, the foreign ministry, the justice ministry, what have you, to receive requests from other countries that say, "Hey, would you please have one of your officials go out and serve this defendant?" If the foreign country does not object, the convention also allows for service by mail, which I recommend against. It seems easy, but it's really not. But the last alternative that we would have is to go to what are called competent persons in that foreign country. In Canada, or at least English-speaking Canada, that's a process server. In France, the Netherlands, Belgium, and the French-speaking province in Canada, Quebec, it's a bailiff. It's actually a person that works for the courts, and we can go to them directly. But again, the foreign country has to allow that, and many of them don't allow us access to their judicial officers.
Mm-hmm. So just to clarify what you're saying, when you say that's the third option, does that mean in the first instance that you have to go to the central authority?
You do not. You do not,
Okay.
and that's the beauty of the way the convention is structured. You've got Article 5, the central authority method, but oh yeah, provided the place you're going to doesn't object, you've got these alternatives.
Mm-hmm.
There's no hierarchy within that mechanism. Everything just depends on whether or not there's an objection.
Hmm.
We don't have to avail ourselves of government channels before we go to private service.
Hmm.
It's very very well structured and very well put together.
Okay. So, I mean, just based on what you're saying, so it sounds like, for example, in English speaking Canada, you can basically just hire a process server.
Yeah, yeah,
Okay.
it's just that straightforward, and we do it regularly. That's actually the most common. Ontario and particularly Toronto.
Hmm.
Uh, that's the most common destination that we go to,
Hmm.
and we
And
almost always do it privately.
right. And so what your firm does, and the reason I ever kind of discovered you is, for example, I had a case. It was in Israel. I was considering at least serving in Israel, and when you're talking about places, I guess where don't they, if you don't have that third option, um, that's where things get very tricky because then you're dealing with the central authority, which is effectively a government agency in another country. So
Right.
rather than trying to do that myself, you offer a service where you can say, "Hey, Aaron, look, I've got to get this served. Just take it and serve it." Right? That.
That's exactly our business model. That's literally all we do. We do get into some things that are tangential, but we literally have we have 5 people that live and breathe in Rule 4F and the Hague Service Convention.
Rule 4F being the federal rule of civil procedure 4.
Correct.
Yep.
Correct. Serving individuals abroad. It also applies for the most part to entities.
Mhm.
But that also is very well drafted and gives us a really good mechanism to work with. It can get a little complex, so that's why we come to the table and clarify things and essentially tell litigators where the landmines are buried
Yeah.
and say let me carry you across that minefield instead of having to walk through it yourself.
Right. Okay. So, you and I spoke in the case in Israel. It sounded like you had that pretty well ironed out, could do it pretty quickly. But it sounds like there are some other countries where, when you're dealing with the central authority, it can get really, yeah, drawn out. Can you just kind of give a little color, elaborate the differences
Sure,
between
sure.
countries?
Sure, we're actually bookended by the what I call the best and the worst, because we can just grab. I'm not making this up. Find a process server in the yellow pages. The Canadians say. For you're not old enough to even have ever used the yellow pages. It used to be a thing.
I remember the yellow
Um,
pages.
Canada is very straightforward. In Mexico, there's only one way to do it, but it takes forever. And it's not because the central authority doesn't have a good handle on things. It's because everything has to run through various levels of judicial bureaucracy before the summons and complaint finally land on some officer's desk that literally gets in his car and drives out to the defendant's office or home to serve the papers. It's very paper heavy, very laden with red tape, and it just takes, from an American perspective, an excruciatingly long time.
Right. So I was reading one of your posts. You, excuse me, you have a blog post. What's the name of it again?
The Hague Law Blog.
Yes, I was reading one there about. It sounds like Mexico and Vietnam are some of the most challenging.
Yeah, yeah. We don't get a whole lot of we don't get a whole lot of call to serve in Vietnam, but Mexico is right up there. It's a top 5 destination, and it can really frustrate litigators and litigants alike. And it's very disheartening when the litigant is somebody of very modest means. They're just trying to get a divorce or just trying to quiet title on a house or some such. But you find out that you've got to serve 4 putative heirs in Mexico, and those costs just skyrocket to get the job done. Unfortunately, there's no alternative down there.
Mhm. Right. And so when you do go outside of an English speaking country, in addition to going through the central authority, there's also a translation requirement, right?
In most of the world, yes. The Netherlands and Belgium are 2 pretty significant exceptions to that. But if the Union Jack didn't used to fly over that thing, you're probably going to have to translate.
Okay. So the Netherlands and Belgium, you can send a complaint in any language, or it's specifically English is the exception.
Specifically English. They and technically they don't require a translation into Dutch or Flemish or French. But if you go through government channels, it's a pretty good idea to do it anyway. Because we go directly to the bailiff, our bailiffs know what the rules are, so we can serve without having to worry about translation.
I see. So I guess Netherlands and Belgium, you have that third option.
Correct.
Okay. Okay.
Correct.
Okay. Cool. Um, so, and I guess this kind of touches on what we've already discussed, but is there such a thing as, in the, excuse me, in the U.S., sometimes you have emergency proceedings. You can get a complaint summons served that same day. Is there such a thing, for example, outside of the U.S.?
There is, but only under the alternatives. We can get things served fairly quickly in places like Ontario, Toronto specifically. I've had it done literally within a matter of hours. Uh, Ireland, England, Scotland, Wales, the British Isles, we've pretty much got a mechanism in place that allows things to happen quickly. But if your defendant is in India or China or Vietnam, Mexico, Germany, even any of the countries that object to the Article 10 alternatives, there is no such thing as quick. So, and that's the downside of the convention.
Right. So I mean, I guess so. If there is some sort of emergency, you're kind of just up the creek.
Pretty much. Wow. Especially on TROs are a big thing because in a lot of courts, a restraining order has an expiration date on it, and there's no hope of getting that thing served before it expires.
Right.
So I have the conversation quite frequently. Don't even bother with it because it's just not going to happen. Don't pay my firm several $1,000s to go get this done. I know it's not going to work in the time frame that you need it to work.
Right. So, and I guess that goes a little bit to another question, which is total costs. If someone wanted to do this out of their own office or basement, they could, right? I mean, it would just be.
It's a lawyer, yeah. Any lawyer can handle a Hague service request. Just like any lawyer admitted in the state of Missouri can walk into traffic court in Kansas City Municipal and appear for a client. Doesn't mean they should. I've only done that once. It was because my wife got a parking ticket and I could not get her out of it. I should have handed it off to somebody who deals with parking tickets. Likewise, this is something that, yes, any lawyer can do it. And if you're going someplace like Ontario or England, yeah, go ahead and DIY that thing. But if you're dealing with China, you shouldn't be doing it on your own. Your odds of failing are pretty significant.
Yeah. Okay, so what happens if a country is not a party to the Hague Convention? So you don't have these mechanisms in place by international law. So what do you do?
It's a double-edged sword, really. On one hand, because the Hague Service Convention is mandatory, if you're serving in a country that's not party to it, unshackles your methodology, as it were. You can just serve pursuant to the rules of the court hearing the case. So if you're in federal court and you want to serve by email, go right ahead. It's okay. From a rule perspective, from a due process perspective, that's just fine. Where you run into problems, though, is if you serve a Taiwan defendant by email and you get a U.S. judgment and then you go to Taiwan to enforce that thing, they're going to laugh you out of the room. They're just, not only are we not going to enforce this thing, we're not even going to recognize it as a valid judgment because you didn't avail yourself of our mechanism of serving. You didn't respect our law in doing it. You took a shortcut. We're not gonna enforce this thing.
Right. So at least as I understand it, if you want to serve a defendant in a non-Hague country, it sounds like you can go under the rules, and the rules allow for mail or email, etc., under the right circumstances. As long as you're enforcing in the U.S., that should hold up, right? A judgment. Right. Yeah. Yep. But if you want to enforce in that country, it's basically a waste of time.
To serve by mail or email, yes, but there's an old-fashioned mechanism called a letter rogatory, in which the U.S. court hearing the case sends a request through diplomatic channels to a judge in the other country. And essentially, it's literally a judge-to-judge communication. Hi, judge, I'm a judge too. Isn't that neat? Hey, would you be so kind as to do me a solid and go out and have one of your officers serve this defendant? Pretty please, I'd appreciate it. And hey, if roles were reversed, I would do the same for you. And it works pretty well in places like Taiwan, South Africa, another common law country. They process them pretty effectively. Those are really the only two where I recommend going that route, because their odds of enforcing the judgment are relatively good. Doesn't mean they're great, but your odds are better in one of those countries if you served by letter rogatory. If you're trying to enforce in a Hague country and you've adhered to the treaty, and you've respected that country's law, service of process is not going to be a basis, or at least not going to be a valid basis for an enforcement tribunal to reject it.
So, and just to touch a little more on the letter rogatory, that's solely a judicial process. Would you get involved in that, or is it just one court talking to the other?
Well, at its core, it is one judge talking to another. But we would draft the thing. Say you had a case in Miami-Dade or Broward that needed to go to Taiwan. I would draft the letter rogatory itself. I would draft the application for its issuance. I would go and get it translated into Chinese. I would get everything printed up, tied up with a pretty little bow, and sent off to the State Department, along with a check for about $2,300. It's the most expensive postage stamp you'll ever buy. But the State Department takes it over to Taiwan, hands it off to Taiwan's diplomat or Taiwan's foreign ministry over there. We have a de facto diplomatic legation in Taipei. It's called the American Institute in Taiwan. It's essentially a corporation owned by the State Department, and that's our diplomatic presence. That office hands the thing off to the Taiwan Foreign Ministry, and then they take it from there. That's what your $2,300 gets you. Wow. It goes to the State Department.
So it literally has to travel through diplomatic channels. You can't just mail it over. Okay.
Correct, and that's one of the things that the Hague Service Convention's objective was to overcome. It negated the need to go through diplomatic channels to make all this happen. Prior to 1965, this was it. This was the only way to go.
Right. Wow. And yes, I can imagine even in one of the, I guess, more effective countries for letters rogatory, that sounds to me like it's got to take months, if not years.
Several months. I've seen them take years in other places. The UAE, I've got one that I think that's been out there a year and a half, and we still don't have anything back on it.
So when you're the plaintiff, or I guess your firm, is there any way for you to kind of track with the foreign central authority in the Hague cases, or in, I guess, in the non-Hague, the equivalent of the State Department in those countries? Is there any way for you to kind of follow up or push things along, or is it just done?
The short answer to that is no. I hate being that direct and that terse. But in the countries where the central authority is responsive and can give us some kind of update, it's not necessary to get an update because it goes relatively quickly. But in countries where things take quite a bit longer, their central authorities aren't very responsive. Right. So that's one of the downsides of the news I have to bear with a client. And we try to manage those expectations really well up front before we even pull the trigger on a request. I try to make plaintiff's counsel aware. Okay, you and I know this is going to take a year and a half. I promise you, either the clerk of court or your client are going to be barking in your ear in 6 months. Why is this not done yet? When is this going to happen? Get me an update. No, is the only answer we can give them. So we strive mightily at the beginning to make sure that everybody involved knows this is going to take much longer than would be acceptable in an American context, significantly longer.
Yeah, and that's to that point. Like in federal court, there's a limit on serving. It's 120 days after the complaint is filed.
It's actually
And
90. It's actually 90 days
90.
under Rule
Sorry.
4M. But it's a beautifully written rule. It says, hey, you got 90 days to serve or you're out of here. And unfortunately, that's where most lawyers stop reading. If they keep reading, they'll see, number one, the court has latitude to extend for good cause shown. But even better than that, the last sentence of Rule 4M says, oh, yeah, that deadline doesn't apply in a foreign country.
Okay.
And places like China, India, Mexico are exactly the reason that the rule is drafted that way, because of the mandatory nature of the treaty that Justice O'Connor talked about. It's you don't have a choice in the matter. So as long as the plaintiff does everything necessary to get the request on file in Beijing or Delhi or Mexico City or Berlin, the fact that it takes more than 90 days is not going to be a problem. They've been diligent. They've done everything they can. And now everything is in the hands of a foreign sovereign who has a ponderous bureaucracy that may not act very quickly. Plaintiff can't do anything about that.
Yeah. So have you ever had to go into court, like in federal court or state court, and just put in like an affidavit or something saying, look, there's nothing we can do?
Yeah, it's something we do. We don't have to do it with any regularity. Fortunately, federal courts get it because all we got to do is point to 4M and a little bit of case law that says, hey, we did our job. There's nothing further we can do. And, oh, yeah, case XYZ says that makes us diligent. You have to give us latitude. State judges are, for the most part, just as cognizant of what the challenges are. We do the bulk of our work at the state level. We do the bulk of our work in about 5 states, and they're the 5 that you would think of right off the bat: New York, California, Illinois, Texas, and your home state of Florida. Your courts are plenty sophisticated. Your judges get it. And in all 5 states, you've got a safety valve. You don't have an automatic safe harbor like 4M provides, but you do have a good cause exception that allows the court to extend. And they extend liberally in situations like this. In New York County, Miami-Dade, Dallas County, Cook County, Illinois, LA, and San Francisco, they deal with Hague service all the time. They get it.
Okay, cool. So, we've been talking about process, which is, formal process typically means a complaint and a summons. So in other words, to start a lawsuit, but there is other form of process, the most common being a subpoena. You just need to take a deposition or get some documents. So, at this cost level and time, time horizons, I guess I would call it, do you get requests for that to do international service of subpoenas?
We get calls and emails for subpoenas all the time, and that's one area where we have to tell them, well, theoretically we could get it served, but it wouldn't do any good. So don't pay me $2,000 to get your subpoena served in some foreign country, because when that thing leaves its own jurisdiction, it loses its teeth. Right. A Florida subpoena can't be just served on me here in Missouri. You have to get a Missouri court to put its sanction on that subpoena, and then serve that Missouri imprimatur, as it were. That's one word. I don't know if it's imprimatur or imprimatur. I've never seen it, or I've never really heard anybody make a decision on it. The bottom line is that Florida summons has to be domesticated to be valid in Missouri. At the international level, there's kind of a corollary process, but it's a different treaty. It's the Hague Evidence Convention that kicks in, and that's essentially a letter-rogatory mechanism. You're still having the U.S. judge ask a judge in Germany or China or Mexico, hey, would you please direct this witness or this custodian of documents to produce the evidence we need. In the lion's share of cases that we get coming across our desk, the litigator concludes, maybe that evidence just isn't worth it. It's
Right.
not as important as we thought it was, because it's going to cost us $15,000 just to get that witness in front of a judge that's going to redline half of our questions. It's not
Right.
going to
Right.
be a deposition.
Mhm.
So that's another bit of disappointment that we have to bring to clients with some frequency.
Right. That's
And
interesting.
what we do get on that, we usually refer out to a colleague in Boston.
Mhm. And I can
Coincidentally,
kind of
his
see.
name's Theodore too.
Oh yeah. Okay. I can kind of see that procedurally also, because when it comes to a complaint, the effective service is if you don't respond in the U.S. court, then there's a judgment, there's a default. But a subpoena, blowing off a subpoena, the result or the sanction is, contempt of court, which someone outside of the U.S. is not going to care about the contempt of a U.S. court.
Right.
So,
Well, and that contempt has no jurisdictional basis
right,
anyway.
right,
If it's a third party in Germany, I'm sorry,
yes,
I've never been to Florida. You have no authority over me. And when I illustrate that concept in reverse, if somebody in Florida gets a subpoena from a German court, they really don't have subpoenas. But if they get a production order from a judge in Berlin, no, I've never been to Berlin. I'm not going to comply with this thing. But until that, whoever's seeking the evidence in Germany, unless they come to Florida and get a court to tell you that you're going to produce, it's got no teeth.
yeah, yeah, interesting. Okay, so this is some really interesting stuff. But let's just talk about kind of your experiences. So, in your line of business, I'm sure you got some wild requests. But what's kind of like some of the most remote destinations you've had to serve in?
The most remote is a little island chain in the Indian Ocean called the Seychelles, or if we're going to anglicize it, the Seychelles. It's a former French colony that became a British colony, and it's just a little tiny island chain, but it's kind of become a haven for financial outfits to set up, particularly blockchain finance outfits and that kind of thing.
Interesting.
And I've had defendants successfully served in the Seychelles Islands. But it is without question the most remote. It literally out in the middle of seawater, 1,000 miles from anywhere.
And it's just the same thing. You send it out to the central authority, and they go serve it.
Yeah, and they get the job done. The Seychelles Central Authority, they know what they're doing, and it's not a big chain of islands, and the islands aren't that big. There's not a whole lot of places that they need to go. I would speculate that they just say, all right, I'm gonna take my daily walk down the block to the registered agent's office, and I'm gonna serve 13 of these actions. So they've got it down to a science.
All right, interesting. And so, how about kind of like the wildest story you've had?
The wildest one really irritated the daylights out of me. It was a divorce case that we had to serve in Germany. Germany's got a really good mechanism in place. We send to the central authority in whatever state the defendant's located in, and a judicial officer goes out. They serve it. Some of them are pretty quick. Some of them take forever. But in this one, my client called me up. He said, "Hey, I'm representing this guy in a divorce. We need to get it served." There's not a whole lot of strategizing involved. We know exactly how to fill out the paperwork, where to send it. It goes over. And about 3 months after I sent the thing, I get a call from a hopping mad client whose client had just read him the riot act saying, "Why did your process server tell my son that his parents are getting a divorce?" Number one, it's not a process server. It's a judicial officer. It's a guy that works for the local court. And we could conclude without a whole lot of analysis that guy's a jerk. because he knew exactly what the case was about. And he knocked on the door and said, "Hi, I'm looking for, Frau so-and-so." And the 14-year-old kid answering the door says, "Oh, that's my mom. She's not here at the moment, but, can I help you?" Then he says, "Yeah, apparently your dad's suing her for divorce. Here you go." That's kind of the outlier. It's
Right.
that's the weird one in a negative way. But some of the others that just shook out to be kind of weird. I was talking earlier about the uh, ability to get things served in Toronto pretty quickly. I got a call at about 8 o'clock in the morning one day saying, "Hey, I got a lawsuit I need to serve on a corporation in Toronto, and I need to get it done by the end of business today." Possible. Let me call my 007 guy up there in Ontario and see if he can do it. And it turns out he said, "Yeah, but I got to charge you double." So I went back to the litigator. I said, "Yeah, but we got to charge you double." And he sent fees. He got everything arranged. We had everything set and ready to go by noon. Emailed everything up to the process server. He went out to this high-rise building and walked in, talked to the security guard. The security guard gets on the phone up to the defendant's office. The CEO of Ashley Madison
Okay.
comes down in the elevator and gets served with the very first. I don't know if it was the first Ashley Madison lawsuit that was filed,
Okay.
but it was definitely the first one served because this guy had no idea. He did not see it coming. We had another one 2 weeks later, and the security guard said, "I'm not even going to call up there. They're not going to come down because process servers have been showing up here all day, every day. They're not going to do it." Well, fortunately, Ontario rules say that you can leave process with someone who is in care and control of the premises.
Oh.
So the security guard ended up being the guy they served. And under Ontario rules, that's just fine. And federal rules say, "Hey, if Ontario rules validate it, we're good with it as long as it comports with due process." And when you're suing a corporation, they don't have the same level of deniability that an individual does.
Yeah. Yeah. No, yeah. All right. Very cool. Good stuff. Sounds like a very interesting practice area.
It
And
is.
really appreciate your time today. If anyone wants to check out your firm, where can they find you?
The easiest place to go is haguelawblog.com, HAGUELAWBLOG.com, or go to vikinglaw.us. That's our firm website. And all of our contact information is on both sites. But the blog is the best place to go if you've got a question. You're looking for, how do I serve in Israel? How do I serve in China? How do I serve in the Hong Kong part of China? That's a quirky one with a whole lot of peculiarities to it. But we really enjoy giving away knowledge around here. And we don't charge a bill until you need us to actually do something. That's something that when I started the firm, 10, 11 years ago, I was very adamant that I'm not going to charge a consulting fee to tell you how this is done. So don't be bashful with questions. We're here anytime.
Yeah, and I can attest. I've spoken to Aaron probably now 3 times on different questions I've had. Haven't had the opportunity to actually hire you, but you've definitely given me a lot of good advice and instruction.
Well,
So,
I'm glad we can help. No doubt.
yeah, all right. And thank you for your time. And to check out my firm, you can visit me at sandlerlawpa.com, and I'm on YouTube at Sandler_law. If you like this episode, please like and subscribe. Thank you for your time, Aaron, and thank you for watching.
My pleasure.